Hi, everyone. Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blanears. This week, I'm going to take a look at how HR immigration teams in the U.S. are managing their F-1 populations. I see a lot of variance in this space, and I think starting a conversation to share ideas and bring best practices to the forefront will be really helpful for any listeners thinking about the processes involved here and shaping their management of F-1 employees in their programs. And this topic was actually suggested to me by an experienced global mobility consultant. Thank you for reaching out and sharing this episode idea and the inspiration. So if there are any listeners who have thoughts, questions, ideas about future Business Immigration Benchmark episodes, don't hesitate to reach out. This is really fun to hear from you directly, the listeners, and answer your questions here on the podcast. So reach out to me on LinkedIn. And if you haven't already, please do subscribe to the Business Immigration Benchmark on YouTube and Spotify. With that, we'll dive right in. So back in March, we surveyed HR immigration and global mobility professionals from 25 companies, and we asked respondents what type of visas their program supports. The companies surveyed had an average foreign national population of 293, and the HR, immigration, and global mobility professionals had an average of 11 years of industry experience. The point I want to bring up here from that survey that we did dive into in a previous episode is that 88%, or 22 out of 25 of these companies in the survey, do support sponsorship for F-1 employees, including F-1 OPT and STEM OPT. So that's all to say that the overwhelming majority of these programs do support F-1s through their OPT and STEM OPT, that 2-year extension EAD cycle. And I think that makes sense because we are seeing, and the stats show that there are a tremendous number of F-1 students who enroll in STEM master's degrees in the U.S. And for competitive companies looking to recruit top talent out of universities, you're inevitably going to run into F-1 students to sponsor. Now, I think the challenges for these programs vary depending on the size and scope and sophistication of their program. When you hire an F-1, depending if the program, you're recruiting directly out of university, you may have some sort of reimbursement policy to pay for the OPT EAD because you probably wouldn't want to proactively pay for the EAD or support the EAD until that foreign national onboards with your company. So I've seen companies both proactively support EADs or the I-765 filing fees or have counsel support that process ahead of the F-1's graduation. That's when the OPT students are applying for the post-graduation 1-year work permit. I've also seen companies who do recruit college graduates. They may even give offers through a internship program they have for the F-1s before their graduation year. Some of those companies will reimburse their F-1 OPT cost of the EAD once that F-1 onboards with the company, meaning that F-1 works with their school or independently to file for that EAD. Once the EAD is in hand, they onboard with the company, and then the company will reimburse the filing fees for that EAD. For the STEM EAD, this is where there definitely is more involved in the sponsorship and where you need to have some sort of protocol in place for the training plan and then the filing of the EAD. So the OPT is an open work authorization, meaning the student doesn't require any company sponsorship. Now, there are individual compliance requirements for the F-1, the student post-graduation, that they have to secure employment within a certain period of time, and they can't have so many days of unemployment. But that's a personal compliance on that foreign national and the F-1 status when holding the OPT. The STEM OPT does have the company get involved in sponsorship. So what this means is when applying for the STEM EAD extension, the student must qualify, have a qualifying degree, and that as part of the application for the STEM extension, the company must opt in and sponsor a formal training plan for the F-1 postgraduate employee. So what this means is the company first must be enrolled in E-Verify, and that there are several attestations in the STEM training plan. So I suspect why some companies do not sponsor STEM EADs is because the company doesn't want to be enrolled in E-Verify, which is an obligation of the STEM program on the company, or they don't want to be involved in the sponsorship effort of the training plan because there are several attestations that the company does sign on to. So if you're a company, if you're a listener right now and you're thinking, oh, I'm not sure what my attestations are, my colleagues, Nikki Matrician and Kimberly Best-Robodeau, every Wednesday, they post their valuable content directed towards HR global mobility professionals on this topic. They dove really deep into the mechanics of the STEM program, as well as I-9 and the E-Verify program and what to expect. So if you haven't already subscribed, go check out WR's Wednesday Rapid Fire with Kimberly Best-Robodeau, Nikki Matrician, where they'll dive more into the HR components of sponsoring the STEM EAD. So I won't dive too deep into it here, but suffice to say that there are several components in which the company must sign on to. So it makes sense why if a company doesn't sponsor STEM OPT EADs, they're not looking to add on these obligations. So that's all to say, when you're running your program, you must have some sort of check or review of a training program. And so I know in the past, I've worked with companies that want my team to develop the training plan, because critically here, the work that the F1 STEM employee must be related to the degree. So you have to show a clear connection between the program that the F1 graduated in and the work that they'll be doing for your company. So there is some analysis and some thoughtfulness that needs to go into the training plan. I've also worked and partnered with companies where they put the burden of the training plan on a manager or a HR partner. And then my team supports the I-765 or the EAD application. So when we say companies sponsor STEM OPT EADs, that's really, kind of a two-part analysis for the STEM training program as well as the EAD. And I've seen programs do it both ways, where they have counsel step in and support the STEM training plan on behalf of the company and the employee, and then also support the EAD. And I've seen companies just peel off and have counsel just support the EAD. I've also seen some programs where they're willing to sponsor F1 STEM or OPT, but they put the burden on the F1 employee, meaning the employee is responsible for timely completing the OPT EAD for onboarding with the company, and the F1 absorbs all of the filing fee costs, as well as the employee, if eligible for the STEM EAD extension, is responsible for developing the training plan directly with their manager and submitting the EAD application themselves. I think the challenge with these types of programs that put the burden on the F1 employee is that for you as the HR global mobility professional that's managing the work authorizations in coordination or partnership with counsel, we'll be doing a ton of follow-ups for these EAD extensions, meaning because the company isn't financially supporting the EAD or working with counsel to support the filing of the EAD, what ends up happening is the F1 student might delay the submission. So you have a ton of follow-up obligation to just make sure that they're doing it. I think there's a burden on the HR global mobility professional of the company, whether or not you are actually financially supporting that EAD extension. So if you're a company that's currently not supporting that EAD extension, I would take a look at maybe forecasting your budget of what really is the extra spend for supporting these EAD applications, because I think it might be worth your time just to manage the timely submission of these EAD extensions for STEM eligible F1s, just to ensure that the EAD is timely filed, to make sure you get this auto work authorization extension of 180 days, important for your program, important for continuity of work authorization. And then it just avoids the sort of tracking chaos if you're consistently having to follow up with F1s who, you want them to stay engaged in their job and you want them to stay focused on learning what their role is. And if you're having to follow up with them to do the administrative paperwork themselves, it could be a frustrating experience. So if you're curious of what that budget looks like in your F1 population, ping me on LinkedIn. I'd be happy to do a forecast for you, or obviously ask your counsel to do the same, just to understand like what's really the cost savings you have here for not supporting the STEM EAD, and how much time are you spending in this sort of follow-up and chasing those STEM EAD extensions. And I think it might be worth your while to have the company proactively work with counsel and submit those STEM extensions. For programs that do support the F1 OPT and STEM EADs, F1 CPT, the whole alphabet soup of any kind of student work authorization, make sure there's training for your onboarding or I-9 teams, because you want to have a backup to make sure that those F1s are flowing into your program. Because if you have a very small program or sometimes a very big program, and as long as that F1 can show valid work authorization, which they can with their student documents of an EAD, they may not automatically get pulled into your purview or into your docket. So you want to make sure that the onboarding folks, I-9 teams, are all trained to identify which folks, like these F1s, should be handed off to you for maintenance and for regular check-ins. The other sort of backup measure is to make sure that all employees, when they're onboarded, have your information and access to an intranet or some sort of resource site, so that they know if they've got questions about immigration, they can reach out to you directly. Because again, when you're onboarding these F1 students with an EAD, they don't require the sponsorship from the onset, but they will, of course, require a STEM extension, at least some sort of check-in, whether the company's supporting financially that EAD or not, for the training plan, and of course for the H-1B pipeline. So you want to make sure that all folks within the company are aware of these folks needing to be under your review. Many F1s will expect support to ensure that they have timely STEM extensions. So if you're a program that does support these, making sure you have a timeline identified protocol document so that the F1 STEM applicants know when you'll be reaching out and how you'll manage the program. Because a 1-year OPT EAD, when they onboard with your company, it's a pretty quick turnaround that they'll be reaching out or wanting to start their STEM extension. This is kind of the time of the year that we start seeing the STEM extensions start to get filed, because most programs graduate their students in June or July. So you'll probably be bombarded with these requests if you haven't already. Another thing to think about setting up here, if you haven't already, is some sort of HRIS feed if you're working with counsel on these F1 STEM extensions, or you're having your F1s tracked by counsel for, of course, H-1B registration pipeline. You want to make sure if you haven't already, set up that HRIS feed to your counsel's immigration portal, so that when new F1s onboard, not only are you notified, but counsel is notified for tracking purposes to, like I said, ensure timely STEM extensions, to make sure if they are on a CPT that they're being prompted for renewal of that, or that the company is aware of when that CPT program does expire. These things kind of, if you're not tracking in an automated way, will come out of the woodwork and end up being a fire drill. So make sure you've got some sort of protocol process, ideally automated, with immigration counsel, to make sure that all your bases are covered to ensure maintenance of work authorization for your unique F1 population. So the specific question that I received from the global mobility consultant that inspired this episode was, what's the best way to track F1 hires for immigration tracking and FICA withholding purposes? How long have they been in the U.S.? Well, so FICA's tricky, and it's actually a U.S. tax law, so I won't be going into the specifics or the substantive regulation here on FICA, but that's all to say that F1s that are subject to FICA, they have the individual obligation to either report that to their company's payroll team or to handle that on the back end with a individual tax advisor. So there's no way on the face of an F1's work authorization documents for a company to know whether FICA should be withheld. So the assumption for the company when supporting an F1 is that FICA is not withheld. They're not subject to FICA unless the F1 discloses some need for the withholding. When the company is aware of when FICA should be withheld, that's when the F1 converts to H-1B. So you, as the HR global mobility consultant, we'll have a list of your F1s that are changing into H-1B status, and working with your immigration counsel, have that list prepared to hand over to your payroll team. So you'll want to be handing over the payroll team the list of F1s that are selected in the H-1B lottery, who have the change of status effective October 1st. And ideally, that list is when the employee's H-1B cap petition has been approved. So that may have already happened or that's coming up. You'll have that list here to hand over to payroll to say that these folks effective 10/1 are subject to FICA. Please implement that in the payroll system. There is another subset of list where you might have F1s that will receive H-1B and effectuate the H-1B at a later date through consular notification, meaning they'll go to the consulate to change into H-1B status. That you can handle in a couple different ways. You can hand over the list of those folks to payroll and have them follow up with the foreign national employee on a regular basis, or set up a plan for when those F1s will be converting to H-1B status, and work with a strategic plan with payroll to know when they will change into H-1B and then FICA to be withheld. You could also set up a communication that puts the obligation on the F1 employee that says when you change into H-1B status, if this is still to be determined. You not only have to notify immigration counsel, but you also have to notify payroll to effectuate the FICA withholding. So that one's a little bit trickier to nail down. I think the best would be to set up the plan and have everybody's expectations managed for when that F1 converts into H-1B. There might be some future travel plans that you're working on, and have that list disclosed to payroll to be aware of, to then withhold FICA. So that's all to say that, FICA isn't necessarily on the radar of U.S. global immigration providers. So, I think this is an astute question from someone who's probably worked within the global mobility tax arena here in that space and hyper aware of this issue. I think, when you're working with an immigration partner, they're not necessarily always putting this on the checklist. So you might still be in the midst of H-1B cap filing. Go ahead and put this on your checklist of things to discuss with your immigration vendor about putting together that list, and what are their recommendations as far as working with payroll to make sure the FICA issue is discussed and disclosed.
All right, Laura, a global mobility manager at an automotive company has about 500 sponsored foreign national employees, including about 80 on F1. The company currently does not sponsor or support sponsorship for F1 employees, but would like to explore setting a new policy up to do so. How would you advise this global mobility manager to develop this new policy from the ground up?
Great question. Yeah, we are seeing, some employers have shied away from sponsoring F1s, meaning they won't hire anyone in an F1 status. Some of that is because they've had struggles or have read about struggles converting the F1s to H-1B given the H-1B lottery percentage selection rate. Sometimes when folks say they don't sponsor F1, they don't financially support the F1 OPT or STEM EAD application fees. So we'd want to understand here, is the company moving from not having an F1 on payroll at all? Or are they moving into, sponsoring the EAD applications? And I bring up that distinction because when you're rolling out a new benefit that employees you currently employ did not receive, that could be a point of friction. So I'm a big fan of, when you roll something out, clearly communicating the context and the why behind rolling out the new benefit to advise all employees so that everybody has access to this new benefit announcement, not just targeting towards, the sort of rolling on new F1s. So we'd want to understand what we're dealing with here. What it sounds like it could be is that they're probably going to start sponsoring financially the EAD applications. So we'd want to work together to develop the rollout of the benefit announcement. And the reason for rolling out this benefit could be because they need to recruit differently, or they're opening university recruitment strategies. And so to do that, they need to be competitive and offer this benefit. But whatever the reason is, we're going to want to say what the intention of the company is to sort of speak to the overall population who may have had to financially carry that EAD application and see that, that the company is now opening the doors to it. So you want to be aware of those potential issues. And then you're going to want to understand and plan with counsel whether your team or the Immigration Global Mobility team is going to take on the training plan for STEM EAD extensions, or whether you're going to pass that off to counsel and work to understand how you're going to hand off information, who's going to be the signatory on the training plans. I have a lot of programs that want the manager of the F1 STEM employee to support the training plan, to be aware of that. Some other programs are fine to just have that HR Global Mobility be the sign-off, but just sort of go through with your counsel for their best practice recommendations. I think the best practice here is to have the HR Global Mobility team member be the signatory on the training plan, because it keeps efficiency in the immigration process for timely application. So those are a few things you'll want to think through with counsel, but the biggest is when you're rolling out this new benefit that you haven't had before, to be very clear, transparent, and effective with that rollout communication. So to wrap it up here, we see a lot of variance with these F1 programs. So there's no right way to do it. It just has to make sense for your program and the way that you manage your foreign national population. This is an exciting episode in that it's a direct response to a question I received from a listener. So encouraging you all that if you have thoughts, questions, feedback on anything within the U.S. immigration or global space, to ping me your thought, question, feedback on LinkedIn. I'd love to hear from you and answer your question on the business immigration benchmark. Thanks for listening.